The second round of President Cyril Ramaphosa's legal challenge will play out in the Gauteng High Court in Johannesburg. The president previously argued that he would suffer irreparable harm if the private prosecution bid against him were to proceed. The president's spokesperson, Vincent Magwenya, outlines the relief sought.
The president is seeking the following relief. Firstly, a declaration that the first two summons issued by Mr. Zuma in December last year be declared unlawful, unconstitutional and invalid. Secondly, the nolle prosequi certificates issued in June and November of last year be declared unlawful, unconstitutional and invalid. And lastly, that the private prosecution of the president by Mr. Zuma be interdicted.
To be successful, the president would have to satisfy several requirements: that there is a clear legal right, that there is a well-grounded basis that he will suffer irreparable harm if it is not granted, that the balance of convenience favors the applicant, and that there is no alternative remedy available to him. However, legal analyst Benedict Perry says the president has made persuasive arguments in his application.
In my view, the president's arguments, at least as they are presented on paper, are the better and more persuasive arguments. The president's argument is well grounded in legal principles and a common sense and business-like interpretation of the language in the nolle prosequi certificate.
However, Perry adds the High Court is likely to send the matter back for consideration instead of granting a final interdict.
The relief of an interdict in the context of a review is not the usual relief. What the court would usually do is either send the matter for reconsideration back to the registrar and the DPP in this instance, or substitute their decision if it felt it was in a better position to make a better decision. That will certainly not be the case in this instance, and it will be interesting to see how the court weighs whether the requirements for a final interdict are met in this case, which in my view is doubtful.
The president in January was granted an interim interdict which shielded him from being hauled before the criminal dock. This, however, did not stop former President Zuma from ensuring that the matter remains enrolled in the criminal court, pending this civil application. Zuma will argue in the civil court that the president has not met the requirements of a final interdict, as he has not exhausted all his options. The Jacob Zuma Foundation has maintained that the president can defend the matter in the criminal court instead of a scenario of parallel hearings in the same matter. Foundation spokesperson Zwanele Manyi says the former president attempted to resolve the matter outside of court and only approached the criminal bench as a last resort.
Now, when those attempts don't work, when people don't do what they're supposed to do, then we have the situation that we have. This President Zuma is here because this is now a last resort.
Former President Zuma is accusing his successor of being an alleged accomplice in the alleged leak of his health records during the corruption trial. Zuma says he wrote to the president on the alleged conduct which he believes compromised the NPA, by extension the criminal justice system as a whole. The president, however, has previously explained that he referred the matter to the Minister of Justice to refer to the Legal Practice Council. The hearings are scheduled to take place over the next 2 days. Kani Mapanga, SABC News, Johannesburg.